Hi, King Dan here. This video is called Jamal vs. Lourdes, Timeline Toward Tyranny. For this video, I take responsibility for anything that I missed. However, I also invite you to consider that anything that I did miss was really an indictment against due process and constitutional principles versus my attempt to document what happened in the Jamal vs. Lourdes case. Alright, Office of Inspector General. On July 19, 2017, the initial filing was submitted. So the Jamal vs. Lourdes case first was put in the public spotlight. And then on July 20th, receipt confirmation of the filing was given. So, okay, we've received the file. On July 25 is when things get a little strange. There's an email that says basically that the Inspector General has advised the King toward a court. Now, this is really strange because the filing was actually given to for the Inspector General. If you look at the Constitution, according to the principles of the Constitution, it's the Inspector General's role, it's Kane's role to look for and to validate that there's no abuses by public employees, archangels. And also, the King is over the Inspector General, so it should be the King advising the Inspector General. So anyways, also on that day, the judge, court clerk, and administrator were appointed, and then a notice was sent to the defendant saying, hey, the case has been officially filed. On July 26, the judge orders each party to assert Chungaguk citizenship or have the case be dismissed. Now, this is interesting because the Chungaguk Constitution was being used, so if you're a Chungaguk citizen, that's where you can claim the Chungaguk Constitution. The same day, the defendant asks if the order of citizenship will be made public, whether or not her decision as claiming herself or not to be a citizen would be made public. On July 27, the judge provided a citizenship form that the plaintiff and the defendant could fill out to assert their status as a Chungaguk citizen. And then on August 7, so about a week and a half later, the defendant never ended up asserting her citizenship, and then the case was dismissed as a result. So after the case was dismissed with the Office of Inspector General, it was really hard to actually keep track what happened publicly after that because there was a lot of misinformation and PR going in many different directions, usually not based on any facts. So what ended up happening according to the records is that a voluntary court of Chungaguk was convened. So this court, convened on August 14th, was the voluntary court of Chungaguk. And then 2 weeks-ish later, on August 29, the second filing was submitted. So basically, the plaintiff, having the first case dismissed, reapplied the case, but then this time to a voluntary court of Chungaguk. On August 30th, the defendant was then notified of the second filing, and then a response to the complaint was requested, saying, hey, you've been having a lawsuit filed against you. We request your response. On September 5th, then a response was provided back to the judge by the defendant. They did a good job. Within a week, that's a pretty good turnaround for quite a long document if you've read it. On September 6 is when another step toward tyranny took place. The judge orders both parties to refrain from publicly discussing the case. So it's called a gag order. So this particular decision was really, really strange. And if you understand constitutional principles, due process, the right to a public trial, you have to question the circumstances of the case necessitating a gag order when, if you look at the circumstances previous to this, leading up to the case, and then even documented circumstances that I'm going to lay out in the rest, actually this plays directly into what the defendant wanted. Remember, previously in the previous slide, she didn't want her status as citizenship or not to be revealed. So already it was in her desire to keep things private, hence the plaintiff's decision to make a public case. Anyway, the next thing that happened is that the defendant asks if online discussion of case details was included in the gag order. Okay, and then here the judge actually says yes. It responds in the affirmative that you're not allowed to discuss case details in the online discussions. So the defendant then asks if all the requests and all the online posts could be deleted, but then the judge rejects the deletion of online posts. The last two things that happen is the plaintiff asks for clarification of the gag order. It's like clearly something's a little bit strange here. And I didn't see a response by the judge, but then the plaintiff goes ahead and formally objects to the gag order in an official writing. 2 days later, the defendant notifies the judge that the official response was posted online without her permission, and the official response is what she was sharing is like the official documentation of the case. And the judge next clarifies that the filings are public record, just like with any public court, but each party themselves must refrain from the discussions. So this is an important clarification because in the defendant's mind, you can see that she was wanting all suppression of all communication, including the First Amendment rights of other people looking in on the case. But the judge made an accurate decision that says, no. Public documentation is to remain public. In fact, what I'm using this is public record as best I could receive it. The defendant then requests that any proceedings be kept for archival purposes only and not disseminated. So now that the judge has clarified that public records are public, she's going back in and saying, okay, it can be public record, just don't make it public. Don't disseminate the public record. And then the judge affirms that the proceedings are public record. However, he does yield to the court clerk for the final decision on whether it's going to be disseminated or not. So I never saw the disseminated information, so the court clerk must have decided against making things public. So it's pretty easy to see that the gag order is being clearly biased toward the defendant. And keep in mind that on September 6th, the plaintiff has already asked for clarification and formally objected to this gag order. Then now, on September 9th, 3 days later, the plaintiff formally files a motion to lift the gag order. However, the judge declines the motion since the defendant was not included in the motion. So that's valid. If a plaintiff is going to file some type of official documentation to the court, then all parties involved must be notified. It's not like a secret motion. Okay, I can understand that. And then on 3 days later, September 12th, the plaintiff refiles the motion to lift the gag order. Now, this is 6 days later where there's no clarification on why this gag order is in place, and clearly the defendant is liking the direction it's going. On September 20th, which is now 2 weeks after the gag order has been in place without clarification as to why, the court has an emergency session notice requested saying, hey, we all need to come together and figure this out. However, the plaintiff declines the emergency session due to the historic September 23rd, 2017 blessing and suggests the court respond in writing to the motion to lift the gag order. He also is in his email questioning the initial grounds of the gag order itself. So, also on this day, Jonathan Franco files an affidavit noting that the defendant's attempt to suppress his online communication and discussions of the circumstances of the case. And Gideon Rauchi actually files an affidavit noting that the defendant has attempted to suppress Jonathan Franco's speech. So if I read through what's kind of going on in the documentation, the defendant actually goes up to Jonathan Franco and wants him not to talk about the case. But in so doing, she actually violates her ability to talk about the case. She's violating the gag order and then trying to keep Jonathan Franco's free speech suppressed as well. And then Gideon Rauchi's affidavit ends up just acknowledging that did happen to Jonathan Franco. On September 21, 2017, the emergency court session was canceled. This was the one requested the day before. Obviously, they were preparing for the blessing. And then on September 30th, the plaintiff ends up sending an affidavit dropping all charges in this voluntary court of Chung-A-Guk. And then October 3rd, the judge accepts the motion to drop all charges, to drop the complaints and all associated charges. So that actually finishes the Jamal versus Lourdes case in public record. And that's it. Thanks.